Next hour, we're going to switch gears to Colin Gray in Georgia. That case just starting within the last minute or so. The judge finished the instructions to the jury before the beginning of openings. This is a father accused of supplying the weapon to his son who went on to a school shooting. He's being tried first. Is that odd? The Crumbleys were tried after Ethan pled guilty up in Michigan. This is reversed. You have dad on trial before the actual alleged school shooter.
I don't know. I thought about the same thing, Ted, that I don't know if, maybe it gives the prosecution somewhat of a test run of their evidence. The evidence is overwhelming. It almost, the prejudicial value can outweigh the probative from the standpoint of, all the carnage and all the death. And it can sometimes sweep a jury along. So it is interesting to me. I don't know if behind the scenes, we never know. Is there some leverage here with the dad that the son may, not go through a trial? I don't know. But I think from what we've seen, you're going to see the dad, with the recklessness that is an involuntary charge for sure.
Yeah, we'll see it all start to play out after a commercial break. Tommy, as always, thank you for your expertise on this Monday. Enjoy your week. We'll get a break when we come back. Colin Gray, they're just getting up and running, opening statements in that Georgia courtroom. We'll take you there when we return. Stay with us. Look at that. Back to Court TV Live. I'm Ted Rowlands. Good to be with you on a Monday. In for Julie Grant. We're in Georgia today for day one of the trial against Colin Gray. He's the father of an alleged school shooter. Colt Gray is his son. Prosecutors say that Colin Gray gave his teen access to a gun and ammunition despite warning signs. His son is accused of killing 4 people. Opening statements are just getting underway. Before we go into court, let's take a look back at the victims in this case. Here's Judge Ashley Wilcott.
4 lives, 4 members of the Apalachee High School community in Winder, Georgia, were lost in a September 2024 mass shooting. Their stories continue to resonate beyond the hallways where they taught, learned, and built lasting connections. 39-year-old Richard "Ricky" Aspinwall, known to students as Coach A, was a defensive coordinator and math teacher.
I know friends that are heavily affected by this because they were that was their football coach. So I mean, they talk to him every day. I know a friend that was his math teacher. He used to say good morning to him every day. Now we can't do that anymore.
53-year-old Christina Arimi, also a math teacher, was remembered as patient, gentle, and committed to helping students succeed. Colleagues say she approached every class with understanding and compassion and made her students feel seen. The school also lost 2 freshmen, both just 14 years old. Mason Schermerhorn was described as funny, creative, and full of life. A kid who loved Disney World, Legos, and making people smile. Friends say he had a big heart and gave even bigger hugs. The sister of fellow freshman Christian Angulu says he was sweet, caring, and so loved by many. Friends from the school say he was kind to everyone, someone who made others feel included. In the days after the shooting, vigils and fundraisers poured in, a reflection of just how deeply these 4 lives touched the community.
All right, so today, the boy has not gone to trial yet. This is the dad. The dad, after his son had made some school shooting threats, bought him a gun, an AR-15 for Christmas back in 2023. So now Colin Gray is on trial for numerous charges, including second-degree murder is the top charge. Basically, his freedom is on the line for the rest of his life if he's found guilty. Let's now head to the courtroom in Georgia, where the opening statements are underway. The state is up first.
Good morning. Before we start, one thing needs to be abundantly clear. This is not a case about holding parents accountable for what their children do. That's not what this case is about. This case is about this defendant and his actions. His actions in allowing a child that he has custody over access to a firearm and ammunition after being warned that that child was going to harm others. This is a case about his actions and the horrific consequences of them. I'm going to take you now to September 4th, 2024. It was a Wednesday morning. It was just after the Labor Day holiday. A 14-year-old boy enters Apalachee High School here in Barrow County. It's a new school for him. In fact, he had been out of school completely the entire previous year. And while the school year was already a month old, this was only his 5th day attending school. As he walked through the crowded hallways, he carried his book bag in front of him. And hidden inside that book bag was a 6-hour M400 AR-style rifle. This 14-year-old boy has an evil plan. He goes to his first period class, located here. It's a computer science class. He sits down at the table, and he puts his book bag with the rifle next to him. At some point during the class, he gets up and approaches the teacher, and he asks her, "Y'all had any active shooter drills?" She says, "Yeah, actually, we had one last week. You were absent." He goes back and sits down. Teacher ponders on this a bit. It's an odd question to ask. She doesn't know this boy very well. He's only been there 5 times. So she emails the school counselor, and she courtesy copies her direct supervisor, the vice principal, about the question the boy had asked. At the end of class, at 9:38, this boy picks up his book bag with the rifle in it, carries it in front of him out of the class, heading to his second period class. That first period teacher stewed on it a little more, and between the class breaks, she decided, I'm going to go up to the office and find the vice principal and talk to her. But at this very moment, that 14-year-old boy is entering his second period class. It's 9:40 a.m. He takes a seat, and he puts that book bag with the rifle in it next to him. 14 minutes later, at 9:54 a.m., that boy gets up, grabs his book bag, and he tells the teacher, I'm going to go to the counseling office, which is located down here. He leaves the class, but he doesn't go down to the counseling office. He goes down what's called J Hall, and he enters the boys' bathroom here. He goes into a stall, locks the stall, and he hides there for the next 26 minutes. Now, 4 minutes before he left second period, at 9:50 a.m., the boy's mother calls the school counselor, who's in this suite here. Now, the boy's mother doesn't live here in Winder. She's down in Fitzgerald, Georgia, which is in South Georgia. It's a 4.5-hour drive from here. But the boy that morning has sent some text messages that will bother her. And he's now not answering his phone when they call or try and get a reply. She's worried about his emotional well-being. Now, the counselor had actually met this boy the week before. He had a panic attack at school, went to her office, and was too upset to go back to class. So the counselor and the mother talk on the phone for 8.5 minutes about this boy's emotional well-being. And at the very end of that call, at the end of the 8.5 minutes, for the first time, that mother mentions to the counselor that this boy has access to firearms. This sends a red flag up to the counselor. She immediately hangs up the phone and she calls the vice principal. This phone call was ended at 9:59 a.m. But remember, The boy had already left the classroom 5 minutes before that phone call ended. 5 minutes before the mother said anything about firearms. And he's hiding in this bathroom where no one knows where he is. 7 minutes after the call ends, at 10:06, the vice principal and the school resource officers arrive at the second period class. Now remember, this boy that the vice principal and the SROs are looking for has only been to that class 5 times. And there's another child in that class who has an almost identical name. And that boy has also left the classroom to actually go to the bathroom. He signed out to go to the bathroom. Second period teacher thinks that's who they're asking for and says he just went to the bathroom. Gives the vice principal that boy's backpack. And the vice principal and the school resource officers head down to the bathroom to find that boy. That boy's just up at the sinks. He comes out with them, they talk to him, they search his book bag, and they realize this isn't the right kid. He doesn't have computer science for first period. They go back to the class. They arrive there at 10:11, back to the second period class. The teacher then tells them, oh, that child has gone to the counseling office, located here, because that's where he said he was going. Vice principal, school resource officers go to the counselor's office. Of course, they haven't seen him. He never made it there. At this point, they decide they're going to go look on the security cameras, see if they can locate this boy. They go down this hall, and it's not on this map. You'll see a more full map later. So around this area is where the vice principal's office is that has access to the security cameras. So they're about right here. At 10:18, the vice principal emails the second period teacher. When did he leave your class? They're trying to locate when exactly he left because remember, this boy's only been there 5 days. They don't really know what he looks like. So they're trying to find him on the video surveillance equipment. So she emails at 10:18, when did he leave your class? 2 minutes later at 10:20, second period teacher responds, he left towards the beginning of class. That's 10:20 a.m. when that email was sent. 1 minute later, at 10:21 a.m., that boy exits the bathroom he'd been hiding in. He's now wearing yellow work gloves. He's carrying that Sig Sauer M400 AR style rifle concealed with a poster board. And he walks back down J Hall towards his second period class. Now, when the vice principal had left that class to go look for him in the counselor's office, she shut the door behind her, and the door automatically locked. This boy is not going to be able to get into his second period class. But next door was another classroom. Right here. It was taught by Cassandra Ryan and Stephen Edwards. And inside that class were the following students: Landon Adams, Christian Angulo, Jackson Beaver, Hayden Bowen, Jalene Brady, Michaela Brown, William Carricker, Marquez Coleman, Melanie Delira Castaneda, Natalie Griffith, Taylor Jones, Kendez Lawrence, Martin Moreno Galdamez, Tyler Moon, Ariana Norman, Brittany Rubio, Mason Skirmerhorn, Ronaldo Vega, and Nautica Walton. At 10:20, Mason Skirmerhorn, who's in that room, leaves to go to the bathroom. And the door does not shut behind him. Mason goes down this hallway. He actually passes the shooter in the hallway, and Mason goes into the bathroom. The shooter goes to his second period class. The door's locked. He knocks on the door. A student in that class gets up, goes to the door to open it for him, but sees through the class at the last second him standing there with that rifle. She steps back from the door. At that exact moment, the teachers also reach the door because they've been looking for this boy, remember? And she sees through the glass him standing there outside their door with that 6 Sauer M400. She immediately presses a button on a lanyard that's around her neck that locks down the school.
Brad Smith telling quite the story there. A prosecutor from the state of Georgia laying out the opening statement. We'll get a break and head right back in for more. Stay with us. It's the murder trial for Colin Gray, the father of the alleged school shooter.
In 2021, Dee Warner vanished without a trace.
Dale Warner. He's accused of murdering his wife, Dee. Rumors of a troubled marriage spread throughout this small community.
She had contemplated divorce several times.
Now, after years of searching for Dee Warner,
her remains are found on the couple's property,
sealed inside a welded shut storage tank.
We're still going to fight to the end to see that she gets her justice.
The hidden murder of Dee Warner. Live coverage today on CourtTV.com.
So did Dad kind of explain everything to you?
Said something about shooting up the school.
Did you say something about school shooting?
Never. I just told him. I don't know what. Maybe they misheard somebody else. I never said it.
You never ever said.
No, I swear.
Do you use Discord?
Discord?
Yes, sir.
I used to. I don't have it.
Man and his son on their porch being questioned by the FBI about an alleged threat of a school shooting. Fast forward to an actual school shooting, and now a father on trial. Despite warning signs, prosecutors say that the dad gave his son a gun after that conversation with agents, basically laying out to the dad that the boy had made some threats about a school shooting, and that's why he's on trial. Let's go back into the courtroom now, pick up the prosecution's opening statement talking about those moments right before the shooting.
The boy then steps next door to the Ryan Edwards classroom, and he opens fire. He fires indiscriminately through the classroom. He hits the following victims. Melanie Delira Castaneda seated here. This is the door he comes into. She's seated here. He strikes her in the left arm with a bullet. Natalie Griffith seated here. Strikes her in the shoulder, the upper arm, and the forearm. Taylor Jones seated here. Struck through the leg. Christian Angulo seated here by the door. He shoots him through the wrist, into the chest. He would not survive. Jackson Beaver, Ronaldo Vega, and Nautica Walton were also in that room. They were struck by shrapnel from the bullets ricocheting around the room. When he finishes shooting, the shooter then leaves. He runs down J Hall. He's looking for more victims. Christina Earmy is a teacher in this classroom. She hears the commotion. She steps out, looks down the hall. The shooter's about here. He shoots her through the neck before she can get back in the room. She would not survive. Richard Aspinwall is coming out of this room on I Hall. He hears the commotion. Joining him is David Phoenix coming out of this room. The two of them start coming down the hall here. They don't get very far because the shooter has now reached this point. He turns his gun down this hallway and sends a hail of bullets towards them. As they dive towards their room, David Phoenix is shot in the hip and in the foot. Richard Aspinwall is shot in the side and the upper chest. He would not survive. The shooter continues down the hallway. He gets to here, tries to get in this door, it won't open. He turns back and heads this way. At this point, Mason Schermerhorn is still in that bathroom. He doesn't know what's happening. He comes out of the bathroom, and he turns away from the shooter, doesn't even see him, heading back toward his second period class. The shooter takes aim from behind, shoots at him, but misses, hits the wall above and in front of Mason. This startles Mason, and he turns and runs the other way, directly at the shooter. He's shot point blank range. He would not survive. Shooter's here. He then aims his gun down K-Hall. And Zane Zinni is locked out of his classroom here. He's in the shooter's sights. Now, before the shooting started, two school resource officers, Donovan Boyd and Brandon King, were in the vestibule area, an atrium, I think they call it, in this area, right outside the vice principal's office. They're waiting for the vice principal to find this boy and go get him. But they're waiting out there in the atrium, and they hear the gunshots coming from this side. And those two deputies ran towards the gunshots. They come down this hallway here, and they turn the corner, and they see the shooter here with his rifle aimed towards Zane Zinni. And they yell for him to drop the gun and get on the ground. And he complies before he gets a shot off at Zane Zinni. The officers rush down here, they secure him, and they secure that 6-hour M400 AR-style rifle. And out of his pockets, they find 3 more magazines loaded. Now remember when the shooter had tried to enter his second period class and the teacher pushed that button? Well, that sent an alarm. It immediately notified law enforcement all over the county. Within minutes, an enormous police and medical response descended upon that school. It was a dramatic and intense scene as the school was cleared and the wounded evacuated. But to make matters worse, they were getting additional threats, fake threats, about other shooters at all the other schools in the county. Law enforcement now had to be diverted to these other schools to clear them, to make sure people were safe. Barrow County deputies Anthony Townsend and Brandon Bazinet were sent to clear Winder-Barrow High School here in Winder. And once they cleared it, then they went next door to Russell Middle School. They cleared it. And just as they were finishing that up, they got a call from their superiors. I was trying to say superior and supervisor at the same time. Their superiors to go to a residence in Barrow County and secure it. They're just given an address. They don't know why they're going there. They're just told, go to this residence and secure it until other officers can arrive. Where they're going is the shooter's house. And when they get there, Colin Gray meets them in the garage. And without any prompting, because remember, they don't know why they're there, they don't know who this guy is. Without any prompting, he blurts out, "I knew it. My little girl just texted me. She's in middle school. She said we're in lockdown." I'm like, God Almighty, please tell me your brother didn't do something. Agents with the Georgia Bureau of Investigations arrived shortly thereafter, and they began a search of the house. And inside that...
All right. Brad Smith, great storyteller. Prosecutor, let's bring in Sonny Slaughter, law enforcement expert trial consultant. Just a very good way to begin this, in my opinion, opening, just taking the jury to the shooting. Something else. Your thoughts?
Ted, you are absolutely right. When juries are preparing and then they are hearing for the first time the details of the case, it really matters that prosecution have a seamless timeline and are able to tell them why they are there. And this prosecutor is laying out everything strategically, naturally, and it's understandable. It is insightful. He has the right tone, the right clarity, and he is just hitting everything line for line, those points which he knows he's going to be able to prove by in actions and in words. This is great for the opening statement for the prosecution.
He started it by saying this isn't about a parent being held responsible for their son's actions, which kind of takes the wind out of the sails of the defense, because that's their whole that's their case, right? It's that we can't blame the parents for what the child does. He was old enough to know better. How effective is that, and to what extent will that be the underlying defense that, yes, Dad maybe in hindsight made some bad decisions, but this was the kid?
Yes, I love that. And, you know, I do a lot of cases for the defense. And when he said that, I was like, oh, now the defense strategy is going to have to meet the measure of what he just came out with, because this is right. You know, Ted, you and I and others have covered the other shooting with Ethan Crumbley. And this prosecutor just stopped those thoughts right away to say, oh, no. That's not what this is. Let me tell you what this is. This was reckless behavior on behalf of a father. This kid should have never had access to a gun. He should have never been allowed to commit this crime. And this is on the father. This has nothing to do with the son, his mentality, his age, because the father did this.
Yeah, and the father's on trial first. The son is still waiting trial. An interesting choice the state has made to try Dad first. Crumbley's went the other way. Now, that was a plea deal, but it's a kind of reverse here. We're watching play out in Georgia. Let's get a break. When we come back, more of the opening statements from the state of Georgia. Stay with us.
So did Dad kind of explain everything to you?
Said something about shooting up a school.
Did you say something about school shooting?
Never. I just told him, I don't know what. Maybe they misheard somebody else. I never said I was right.
You never ever said.
No, I swear.
Do you use Discord?
Discord?
Yes, sir.
I used to. I don't have it.
This morning, opening statements are underway for Colin Gray. He's the dad of an accused school shooting. He's facing 2 counts of second-degree murder. Let's go back into the courtroom now. We're watching the prosecution's opening statement. We'll pick it up right where we left off.
And inside that house, in that 14-year-old boy's bedroom, on the wall, they find this shrine, for a better word. Those pictures are all of the same person, Nicholas Cruz. Nicholas Cruz was the person that in 2018 went into Marjorie Stoneman Douglas High School in Parkland, Florida, with an AR-style rifle. And there he killed 17 students and faculty and wounded another 17 more. Investigators look at this and they begin to wonder, who is this kid? His name is Colt Gray. He's the oldest son of Colin Gray. His mother is Marcy Gray. He has a younger sister named Jenny, who was 13 years old at the time of this incident. She was actually going to Heyman Morris Middle School, which is directly next door to Apalachee High School. He has a little brother, Coley, who was 8 years old, was going to his elementary school. Now, Colt Gray, raised here in Bexar County, he went to Statham Elementary School up until 4th grade, up till the beginning of 4th grade. And in the beginning of 4th grade, he was withdrawn from Statham Elementary School because the family had moved. They moved to Gainesville. And he goes to White Sulphur Elementary School, but only for a few months. Because again, the family moved again. Now they moved to Cumming. And he goes to Chattahoochee Elementary School. But again, only for a few months. In March of 2020, they moved to Fitzgerald in Ben Hill County, Georgia. It's South Georgia, kind of east of Tifton. Because there, Marcy's mother and father, Deborah Polhamus and Charlie Polhamus, live, and Deborah Polhamus's mother, Marcy's grandmother, Colt's great-grandmother, had passed away and left the house. So there's an available house for them to live in. So they moved down to Fitzgerald on March 4th of 2020. But if you remember that day, that's the week before COVID shut everything down. That was the end of Colt's 4th grade year. 5th grade. Now this is going to be the fall of 2020 into the spring of 2021. That's 5th grade year. Colt goes to Ben Hill Elementary School. But remember, this is when COVID is raging, and it's mostly virtual. He's mostly at home using the school computers. The next year, 6th grade, fall of 2021, he starts a new school, Ben Hill Middle School, because he's in 6th grade now. And early in that year, 11-year-old Colt, at home, using the school computer, searches the word abuse. A few hours later, he searches the phrase, "How to kill your dad." That was on September 19th, 2021, 3 years before he took that rifle into Apalachee High School. School resource officers sent to the house to check on him. Everything's fine. It was just a mistake. Misunderstanding. But a DeFax case is opened on the family. But the family leave Fitzgerald and move to Jackson County 6 weeks later in November of 2021. So in November, they come up here to Jackson County, Georgia. But they don't enroll the kids in school until February of 2022. Colt finishes out his 6th grade year at West Jackson Middle School. 7th grade, fall of 2020, 1 year after he searched How to Kill Your Dad, and 2 years before Apalachee, 12-year-old Colt starts Jefferson Middle School. It's his 7th school in 4 years. That Halloween, halfway through the semester, Marcy, his mother, gets drunk, passes out in the car in the driveway of the house. Jenny and little Coley are trick-or-treating, and they get separated. Coley gets lost. Authorities are called. Another DeFax case is opened on the family. Marcy and the 2 siblings, little Coley and Jenny, they moved back down to Fitzgerald in November of 2022. But Colt stays up in Jackson County with the defendant. DeFax caseworker Tamika Mitchum is monitoring Marcy and the 2 siblings down in Fitzgerald. And DeFax caseworker Michaela Anderson is monitoring Colt and the defendant up here in Jackson County. And starting in March of 2023, during his 7th grade year, Michaela Anderson visits his residence monthly. Every month, she shows up to check on Colt, see how he's doing, check on his well-being. And the defendant always says the same thing. Colt's doing well in school. He doesn't need any counseling. But that's not really true. Colt is full of intense anger, and he's having a hard time dealing with it. On Sunday, May 21st, 2023, this is the end of Colt's 7th grade year at Jefferson Middle School. In fact, classes had ended that Friday, and this is that Sunday. And on that Sunday...
Okay, get a break. First, Sonny, this kid needed some help, maybe a hug, not a gun.
Exactly, Ted. And the father was really irresponsible and not recognizing this. And actually, so was DeFax. You know, we have to take these incidents seriously, and he should have gotten help, not been placed with a gun in his hand. And what father or parent would do that? That is just, he was too young. He's not knowledgeable about how things operate in life, where you can't get upset and then just go and start killing people. The father is definitely on trial for the reasons that he needs to be. And this case is going to once again be something that plays out, becomes precedent setting in how these school shootings are being addressed and handled going forward.
Yeah, and the prosecutor doing a magnificent job of bringing jurors not only to the school for the shooting, but then backfilling the story of where the kid came from to get to that point, and the role the parents play, the role they played. And oof, it's just heartbreaking. The Halloween drunk mom, the whole thing. Let's get a break. When we come back, we'll head back for more of the prosecution's opening statement. Stay with us.
This is the story of the Richins. Eric, a father of 3, met an untimely end. And Corey, his widow, wrote a children's book on grief.
She's also charged now with his murder.
He was faced with betrayal and terror.
I know her innocence.
Is their story a tragic romance?
Or a twisted tale of grief?
The truth will come out.
The Grief Author Murder Trial. Live coverage begins February 23rd on Court TV.
Opening statements are underway in the case against Colin Gray. His son is an accused school shooter. Let's go back into the courtroom. The prosecution laying out their case for this jury.
And on that Sunday, the Jackson County Sheriff's Office gets a tip from the FBI. There's an app that you can get on your computer called Discord. And this app is popular with video game enthusiasts, but it allows people from all over the world to talk to each other on the computer. And users in a chat room on this app, a true crime chat room, report to the FBI that another user is threatening to shoot up an elementary school. This user is threatening to do this. It says they have access to guns. It says they plan to do it within the next 2 years. The FBI passes this tip on to Jackson County because when you look at the IP address of that user, it comes back to a Colin Gray and an address in Jackson County. Deputy Justin Elliott and investigator Dan Miller go to that address. Now, the current resident of that address has 2 daughters, and they don't use Discord. But they're new to that address, and they keep getting the mail of the previous tenant, Colin Gray. Deputy Elliott and investigator Miller then go to his new address. They speak with the defendant at his house, and they tell him about this threat on Discord. And they ask him, does Colt have access to guns? Which he does. But the defendant says that he and Colt, they take this school shooting stuff very seriously. And Colt denies to these officers that it was him on Discord. He says his Discord account got hacked. The defendant makes no mention to these officers that less than 2 years before, Ben Hill officers had also been to his house when Colt searched how to kill your dad, also on a computer. But before they left, investigator Miller asked the defendant to please restrict Colt's access to guns. Less than 3 weeks later, when DeFax agent Michaela Anderson goes back out to the house like she's been doing monthly to meet with the defendant, and again, she asks, how's Colt doing? He makes no mention to her of this visit from the sheriff's office. 2 weeks after that, on June 23rd, the defendant signs a lease to move out of Jackson County into Winder. But he doesn't tell Michaela Anderson he was planning on doing that, and he never tells DeFax that he did do that. She just keeps going to an empty house. 2 months later, in August, it's time for another school year. Colt's not at Jefferson Middle School anymore. 13-year-old Colt is enrolled at Heyman Morris Middle School. This is the middle school in Winder that's directly next door to Apalachee High School. This is supposed to be his 8th grade year. But he's withdrawn from that school 3 days later. He never attends it. Instead, Colt goes back down to Fitzgerald to live with his mother, Marcy. And while he's in Fitzgerald, Colt is still filled with anger. He's still having trouble dealing with it. He's becoming violent. He breaks windows. He cuts up things with a knife. He even starts cutting on himself with that knife. These are the scars from after he was arrested after the shooting a year later. Colt's grandfather, Charlie Polhamus, is at his wit's end. He actually calls the police on Colt. And at the beginning of October 2023, just a few weeks after being in Fitzgerald, Colt comes back up here to Winder to live with the defendant. But he does not attend school. 2 weeks later, on October 13th, down in Fitzgerald, Marcy, who you remember still being checked on by DeFax, tests positive for drugs. She's going to lose the kids. DeFax worker Tamika Mitchum, who's been monitoring Marcy, calls the defendant, tells him to come down to Fitzgerald to pick up the other 2 kids, Jenny and Coley, and bring them back up. He now has sole custody of the 3 kids. Marcy's to have no unsupervised contact. But Tamika Mitchum also stresses to the defendant to get the kids in school and counseling as soon as possible. He does neither of these things. 3 weeks after the kids are brought up here, on November 6th, 2023, back down in Fitzgerald, Marcy basically goes crazy. She wants to come up to Winder. She wants her mother, Deborah Polhamus, to bring her to Winder. And Deborah Polhamus says, "You ain't going to Winder." So Marcy duct tapes her mother to the chair, steals her car, drives up to Winder, goes to the defendant's house, keys his truck, and gets arrested. She spends some time in the Bexar County Jail before she's transferred to the Ben Hill County Jail for the charges down there. And while she's down there, she's released on bond to an inpatient drug treatment facility in South Georgia. She has no supervision during this time over Colt. Now back up here in Barrow County, it's been a chaotic few months for Colt. But that Christmas, after the cuttings and the things with the Jackson County and the moms going crazy, testing positive drugs, that Christmas, the defendant, 7 months after he was told by Jackson County Sheriff's Office of possible school shooter threats and being asked to restrict Colt's access to guns, the defendant buys and gives 13-year-old Colt that Sig Sauer M400 as his Christmas present. And he allows Colt to keep this rifle propped up in Colt's room. Now in February of 2024, 2 months after this Christmas, in February, Colt's siblings, Jenny and Coley, are finally enrolled in school. They've already missed 4 months of school, but they're finally enrolled. Colt does not attend. He misses the entirety of his 8th grade year. But during that spring, when Colt's not in school, the defendant continues to buy accessories for his Christmas present rifle. He buys a sight-marked ultra-shot sight to go on the rifle. He buys a bungee sling to go for the rifle. He buys an accessory rail set. He buys a 45-degree offset iron sights. And he buys a lot of ammunition. That summer, 2024, Colt is now 14. It's just a few months before he takes his Christmas present rifle into Apalachee High School. July 6th of that summer, Marcy gets out of rehab in Fitzgerald, and the defendant picks her up and brings her back up to Winder. It's her first contact with Colt in 9 months. Now, Colt, who had always been quick to violence.
All right, we're going to slip in a commercial break here. When we come back, more of the opening statements on behalf of the state of Georgia in the case against Colin Gray. Stay with us. You're watching Court TV, your front row seat to justice.
Welcome back to Court TV Live. I'm Michael Ayala. We begin this hour in Georgia, where the father of an accused school shooter is standing trial for his alleged role in that deadly shooting. Now, Colin Gray, the father of Colt Gray, is charged with 29 counts in connection to the deadly mass shooting at Apalachee High School back in September of 2024. Prosecutors say that Gray bought his son the assault-style weapon that was used in that shooting as a Christmas gift, despite knowing of his son's deteriorating mental health and obsession with school shooters. Before we get into court, here's Court TV anchor Ted Rowland with more on the case against Colin Gray.
The smart board said lockdown, and everybody ran into the corner. And the next thing you know, I just start hearing gunshots like crazy.
September 4th, 2024 started as a routine morning at Apalachee High School in Winder, Georgia, about 45 minutes outside of Atlanta. It would then turn deadly when police say a 14-year-old freshman, Colt Gray, opened fire, killing 4 and injuring 9 others.
There was 10 shots, about a 3-second or 4-second pause, and then 7 more.
According to investigators, Gray carried an AR-15 style rifle onto a school bus that morning, the barrel sticking out of his backpack wrapped in poster board. They say he left his second period class and started shooting, first inside a classroom and then down a hallway. 4 people would lose their lives that day, 14-year-old students, Mason Schermerhorn and Christian Angelou, 53-year-old math teacher, Christina Arimi, and 39-year-old football coach, Richard "Ricky" Aspinwall.
In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you.
Colt Gray has been indicted on 55 felony counts, including 25 counts of aggravated assault. The teen has pled not guilty. He is not the only one facing charges in this tragedy.
How old are you, Mr. Gray?
54.
Colt's father, Colin Gray, faces charges of second-degree murder and involuntary manslaughter. Prosecutors say Colin admitted to buying the rifle that his son used in the mass shooting and did so knowing that the teen was a danger to himself and others. He's pled not guilty to the charges.
So did your dad kind of explain everything to you?
He said something about school shooting up a school.
Did you say something about school shooting?
I just told him, I don't know what. Maybe they misheard somebody else.
Deputies interviewed the Grays about a year before the shooting, based on FBI tips about alleged threats posted on the online platform Discord. In that interview, Colin said his son had been struggling with bullies, a new school, and his parents' divorce. He also said that Colt was very familiar with guns and hunting, saying he knew the seriousness of weapons.
I don't know anything about him saying like that, and I'm gonna be mad as hell if he did.
and then all the guns will go away, and they won't be accessible.
Investigators determined at the time there was no probable cause to take further action, citing inconclusive evidence. The morning of the shooting, Colt's mother, Marcy Gray, said she called the school warning of an extreme emergency after receiving a text from her son reading, "I'm sorry." Here's what she told ABC News.
Between my gut feelings, the text messages, and now this email, y'all need to go, like, run.
If convicted of murder, Colt Gray faces a life sentence. He is not eligible for the death penalty due to his age. His father, Colin, has been granted a change of venue in his case. If he's found guilty of murder, he could face up to 180 years in prison.
All right, I want to get you back into court now for more of the state's opening statement.
Who had always been quick to violence and suffered from severe anxiety, begins to spiral out of control. He's fighting with his father. He's throwing things at people. He's putting holes in his sister Jenny's door. But the rifle stays in his room. On July 20th, Colt has a panic attack at the house. He comes in the living room and he actually asks his parents to call 911 for him. But they don't call anyone. His mental health becomes so bad that the defendant and Marcy together begin giving Colt Marcy's prescription for Zoloft. They're just giving it to him themselves. They worry he's suffering from depression, but they don't take him to see a doctor. It's around this time that Colt puts those pictures of Nicholas Cruz, the Parkland shooter, up in his room. And the rifle stays in his room. August 14th, 2024, 3 weeks before the shooting. It's Colt's first day of Apalachee. School had started 2 weeks earlier, but this was Colt's first day. He missed the first 2 weeks. He had not been inside of school for 15 months. Not since the sheriff's office came to his door about the threats to shoot up a school. And that morning, Colt again is spiraling out of control. He sends a text message to the defendant at 6:49 a.m. He writes, "2 minutes later, at 6:51 a.m., he sends this text message to the defendant. Whenever something happens, just know the blood is on your hands." His first day of school. And the rifle stays in his room. The very next day, August 15th, Colt skips school. He gets into a fight with his mother, Marcy, when she goes into his room to try and get the rifle away from him. With rifle in hand, he shoves his mother to the ground and she hits her head on the wall. She then asks the defendant to please take Colt's rifle and lock it up. He never does. Marcy then has had enough. She goes back to Fitzgerald, once again leaving Colt into the care of the defendant. And the rifle stays in his room. The next day, after this altercation with his mother, Colt asked the defendant to get him 150 rounds of ammunition. The defendant responds to him, well, he needs to pay for everything first, but he will. He will. Now, Marcy's down in Fitzgerald, the defendant's up here, but they're still communicating with each other by phone and text. And they begin to worry that Colt needs to be institutionalized. He needs to go to an inpatient facility. He's so bad. They search for places and resources, but the defendant never follows through. He never takes Colt to see any professional, and the rifle stays in his room. August 26th, 9 days before the shooting, Colt has another panic attack, this time at school. It's the one I referred to earlier in the opening. It's only his 4th day he attended school. Remember, he missed the first 2 weeks of school, and he skipped school 5 of the next 8 days. Colt leaves his second period class that day. He goes to the counselor's office. He's too distressed to go back to class. They call his father, but his father can't come to get Colt. Colt ends up spending the entire school day in the counselor's office. That night, on the phone, Colt asked his grandmother, Deborah Polhamus, if he did something terrible, would she still love him? This bothered her so much, Deborah Polhamus, that the next morning she drives up to Winder from Fitzgerald. And on the way, she calls Advantage Behavioral Health Systems. It's a crisis stabilization inpatient place in Athens, Georgia. She talks to them on the phone, and they tell her he must be brought in by a parent. Marcy's in Fitzgerald. The defendant is here. They tell her that Saturday is a great day to come in because most people don't realize they're actually open on Saturdays and you can just walk right in. But he needs to be brought by a parent. Deborah asked the defendant to take Colt on that Saturday, which would have been August 31st. He doesn't. Wednesday, August the 28th, Colt skips school. This is 2 days after that panic attack, the day after Deborah Polhamus has called Crisis Advantage Behavioral. Colt tells the defendant that he hears voices telling him what to do. This is 3 days before the defendant is supposed to take Colt to Advantage Behavioral, and 1 week before the shooting. At 7:44 a.m. that morning, Colt texts the defendant, I have to kind of dance around the inconvenient truth at times. I have no control over what these things say and tell me to do. And the rifle stays in his room. Colt skips school again the next day, which is a Thursday. That Friday and Monday, school is closed for the Labor Day holiday. And that Tuesday, September 3rd, Colt skips school again. That brings us back around to that Wednesday morning, September 4th, 2024. Those pictures of Nicholas Cruz are still on his wall, and that rifle is still in his room. The defendant leaves to take little Coley to school. Jenny leaves on her bus for Heyman Morris Middle School, which again is directly next door to Apalachee High School. Colt gets...
That rifle is still in his room. What an incredible line, sort of weaving its way through this really powerful opening statement by the state. We'll have the rest of their opening statement when we return. Keep it here on Court TV.
In 2021, Dee Warner vanished without a trace.
Dale Warner. He's accused of murdering his wife, Dee. Rumors of a troubled marriage spread throughout this small community.
She had contemplated divorce several times.
Now, after years of searching for Dee Warner,
her remains are found on the couple's property.
Sealed inside a welded shut storage tank.
We're still going to fight to the end to see that she gets her justice.
The hidden murder of Dee Warner. Live coverage today on Court TV.
right, I want to head back now to Georgia, where we're watching opening statements in the Gave My Son a Gun murder trial, really aptly named. Prosecutors say that Colin Gray gave his son an assault-style weapon despite knowing of his mental health issues ahead of that deadly Apalachee High School shooting. On September 4th of 2024, the 14-year-old Colt Gray took the gun to school and fatally shot 2 students and 2 teachers. He had gotten that gun for Christmas. Well, now his father could be facing the rest of his life in jail if found guilty of his alleged involvement in that shooting. And the involvement is really just giving his son a gun, knowing he had mental health issues, and this could have happened, the foreseeability of it all. Let's get you back to court now for the remainder of the state's opening statement.
Colt gets his rifle, gets extra magazines, puts them in his book bag. He wraps a poster board around the part of the rifle that sticks out of the bag, and he takes a hat with a Fender guitar logo on it, a stocking hat, and puts it over the top so you can't see it. And then he heads out to meet the bus. A few hours later, just like he'd been warning he was going to do, Colt murders 4 people. Now, after the shooting, which I will remind you happened at 10:22 a.m. So after that, at 11:01 a.m., Jenny, the daughter, texts her father, 3 people are dead at the high school. The defendant texts back a minute later, how do you know? How do you know? She responds, people are saying, and there was an email. Please, I'm scared. She then texts the defendant, I can't call you, I'm in a lockdown. At 12:19, the defendant texts Jenny, Jenny, have you talked to your brother? Jenny replies, no. But I think we're thinking the same thing, and I don't want to talk about it over text. 1 minute later, the defendant replies, yep, 10-4. I'll be here in just a few. Let me know when you get back in the building and when I can come get you. A few minutes later, the defendant arrives at his home, not Jenny's school, not Apalachee. He goes home, and he runs straight to Colt's room. He has to confirm what he already knows. He goes straight to Colt's room to see if that gun is missing. And it is. Moments later, Anthony Townsend and Brandon Bazinet arrive at his house, and he utters those words, I knew it. Now, ladies and gentlemen, the charges in this case, it's the same acts that he did. The charges are divided up between whether or not the victim of those acts was a child or an adult. If they're a child, the charges that stem from their victimization would be cruelty to children, because you have to be under 18 for cruelty to children to apply. But through his negligence of allowing Colt to have this gun, knowing what Colt was going to do, he caused cruel and excessive physical pain to the children. That's cruelty to children in the second degree. If that cruelty to children in the second degree results in death, like with Mason Skirmerhorn and Christian Angulo, that is murder in the second degree. So the cruelty and the murder in the second go together. They apply to the children. The 2 adult deceased, Christina Irmy and Richard Aspinwall, they're above the age of 18. The defendant is charged with reckless conduct, same act, recklessly allowing his child, that he knew this was going to happen, to harm someone else. And because they died during the commission of reckless conduct, that is involuntary manslaughter. So for the adults, it's involuntary manslaughter based on reckless conduct. All the other children who were either struck by a bullet or in that Ryan Edwards classroom when the bullets started flying, they're the victims of charges for cruelty to children in the second degree, either by the physical pain it caused or the emotional anguish it caused. And the adults that were injured or put in harm's way, David Phoenix, Stephen Edwards, and Cassandra Ryan, got that one, Cassandra Ryan, excuse me, those three adults, they're the victims of the reckless conduct. Now, at the end of the case, we'll come back before you and ask you to render a verdict of guilty. Thank you.
Mr. Hobbs. Thank you, Judge. Good morning, ladies and gentlemen.
All right, I want to bring in our guest for this hour to discuss what we just saw. Joining me now from Atlanta, Georgia, criminal defense attorney Josh Schiffer. Josh, great to see you. And I want to get into the legal aspects of this in a second. The little last part there, I think, was very interesting, and I'm sure you have a lot to say about it. But first and foremost, I want to get your reaction to that opening statement, which I thought went very, very well for the state.
I agree with you, Michael, and good morning. This is a very highly watched trial, not just in the true crime universe, but really the academic and professional circles as well, because for the second time in American history, we are seeing somebody prosecuted not for what they did with their firearm, but what a third person used their firearm for in committing a crime. And really the theory behind this case isn't ownership of a firearm or committing a direct statutory crime, but it's one where the father is being exposed, that's Colin Gray, to criminal conviction for what he should have known or what he should have reasonably known when it came to allowing his son to have access to a firearm. And this case has pretty unique facts. Knowing all this going in, I thought the state did a very good job tamping down the politics and the emotion and just presenting their theory of the case in a straightforward, business-like manner.
Yeah, no question about it. And, you know, just the rifle stays in his room. He played that. He said that throughout his opening statement. I thought was very effective. But towards the end, he basically said, this is a case about child cruelty, and through the child cruelty, we can get that second-degree murder conviction because this defendant knew what his son was going to do. I think that might be a problem for this jury.
Yeah, no, and that's the real crux of this. And I'm very much looking forward to seeing what the defense attorney led by Jimmy Berry, a legendary lawyer here in Georgia, how they're going to attack that juncture, that nexus point where the criminal culpability extends to the father, because after all of these contacts, after all of these notifications that, hey, there's something going on here with your son, shouldn't the father have taken a more responsible pathway forward and remove an ultra-hazardous instrumentality from his son's access? And that's really the crux of it. What are jurors gonna think when they say, hey, this dad got told by a bunch of cops that something was going on with his kid, and it was kind of concerning and possibly dangerous. They didn't tell him specifically, oh, you need to make sure your child's locked down and make sure that your kid doesn't have any, no. But they assumed that as a regular, rational, responsible citizen, the dad would do the right thing. And that didn't happen. But how do we criminalize that in front of a jury of 12 people, especially when it involves the Second Amendment?
Yeah, it's tough. A lot to discuss here. Josh, thank you so much for that. We're going to step aside here, folks, and take a break. We'll be back with more. So keep it here on Court TV. All right, folks, before we head back into the courtroom, I have a quick update out of New Jersey where, in case you missed it on Friday, a jury reached a verdict in the case against Paul Canero.
How do you find as to count one of the indictment charging the defendant, Paul Canero, with the murder of Keith Canero?
Guilty.
Count two. How do you find as to count two of the indictment charging the defendant, Paul Canero, with the murder of Jennifer Canero?
Guilty.
Three. How do you find as to count three of the indictment charging the defendant, Paul Canero, with the murder of Jesse Canero?
Guilty.
Count four. How do you find as to count 4 of the indictment charging the defendant Paul Canaro with the murder of Sophia Canaro?
Guilty.
Guilty on all counts and virtually no emotion from Paul Canaro. Now, prosecutors had argued at trial that Paul fatally shot his brother Keith and his wife Jennifer and then stabbed his niece and nephew to death before setting their house on fire and then setting his own house on fire to make it look like a targeted attack on both brothers. Well, he is scheduled to be sentenced on May 12th, and of course, he faces life in prison. All right, let's head back to Georgia now, folks, where we've been following the Gave My Son a Gun murder trial. Colin Gray, the father of accused school shooter Colt Gray, is facing second-degree murder charges for his alleged role in the shooting at Apalachee High School that left 2 teachers and 2 students dead. Now, prosecutors say Colin gave his son an assault-style weapon as a Christmas gift, and he was aware that the child's mental health had deteriorated in the weeks before the shooting. All right, let's head back into that courtroom now. It's time for the defense's opening statement.
We have to begin with what every person in this courtroom already knows. What happened at Apalachee High School was tragic. It was horrific, it was terrifying, and it was heartbreaking. Nothing said in this courtroom can change that. Nothing that I'm going to say is meant to diminish that. You're going to hear emotional testimony, you'll see photographs, you'll see videos, you'll hear about the fear, the chaos, and the terror that Colt Gray inflicted on that school and this community. But your job is not to decide whether or not that was tragic. We all know that it was. Your job is to decide something much more specific. Your job is to decide whether or not Colin Gray knew what Colt was going to do. Because the state is not just prosecuting the shooter in this case, they're prosecuting the father as well. I want you to remember something as we begin. The courtroom is not a place where we punish people because we're angry, where we punish people because we're grieving. It's not a place where we punish people because we feel someone has to pay. This is a place where we follow the law. And the law requires proof, and the law requires evidence. And the law requires that the state prove its case beyond a reasonable doubt. That burden never shifts, not for a single moment. The state's theory will be simple. They'll tell you that Colt Gray allowed his son access to firearms and ammunition. Colin Gray had warning signs, and then Colin Gray, knowing that these were warning signs, consciously disregarded those warning signs. That he should have known his son would, not could, that his son would harm someone. And because the son later committed this school shooting, therefore Colin Gray must be guilty, must be criminally negligent, because he knew this would happen. That's their theory. But what you'll learn from the evidence is that case is not that simple. The evidence will show a teenager who is struggling mentally, a teenager who is deceptive, a teenager who hid his true intentions from everyone, from his family, from his counselor, from his siblings, from DeFax, from law enforcement, and most especially from his father. The evidence will show a father who did not ignore his child. He did not abandon his child. He did not turn his back on his child. The evidence will show between Colin Gray and Colt Gray daily contact, daily effort, and active steps by Colin Gray to seek mental health intervention for his son through the school. The evidence will show that the most important facts, the planning of this shooting, the concealment of this shooting, and the timeline of this shooting were hidden by Colt Gray from his father. That's the difference between tragedy and criminal liability. And this case is about whether the state can prove criminal liability by showing that Colin Gray knew that Colt was going to do this, knew that Colt was going to harm someone else. You cannot hold someone criminally responsible for failing to predict what was intentionally hidden from them. You'll learn about Colt Gray's state of mind that at the time no one knew. You will learn that months before the shooting, Colt had notes hidden on his cell phone from April of 2024, private notes that appear to be the planning stages of this shooting. Those notes were not known to Colin Gray. Those notes were not shared with Colin Gray. There is no evidence of that. You will learn something else. The plans reflected in those notes show that the shooting was initially planned for February of 2025 to coincide with the anniversary of the Parkland High School shooting committed by Nicholas Cruz. The plan reflected in those notes was that that time was going to be when the shooting happened, not in September of 2024. Something changed. The evidence will suggest and support that Colt accelerated his plan. And there's evidence suggesting that that acceleration was tied to the fact that Colin Gray was actively seeking mental health treatment for his son through the school at that time. There are emails to the counselor. There's paperwork he filled out. There was already in motion, already in place, an appointment for Colt to meet with the counselor and to meet with the mental health specialist the very next day, September 5th. Colin Gray did not know about the plans. Colin Gray did not know that Colt was planning to do this and that he would in fact go harm someone else. The behavior that Colt exhibits, the behavior that you'll find from his notes in his cell phone, from his text messages, show that he was actively keeping this information from others, from law enforcement, from DeFax, from counselors, from professionals who know to look for these signs, and most especially from his dad. The state will point, and they've already mentioned to you, an incident in May of 2023 when two Jackson County sheriffs went to Mr. Gray's home to talk to Colt. Fortunately, this interaction is on body-worn camera video, so you'll get to see the whole episode. You will see that Colin Gray is cooperative. You'll see that he brings his son out. He tells the officers that he takes this kind of thing seriously. He tells the officers, you tell me that he did it and those guns are gone today. That is on video. That is undeniable. But the officers don't tell him that. The officers say that they're not sure that it was him that made the threat. He tells the officers that he has a gun in the home. He says that he has a son who is somewhat isolated, who's on the computer a lot. He says that when he was young, he used to enjoy hunting with his father, that they would go deer hunting. And so he was introducing Colt to deer hunting, that they had gone out a year before. Colt had killed his first deer, that the gun that they had was for deer hunting. The gun was to get him outside, which the officer in the video approves of. Get him away from the computers, that's good. But Colin tells the officers, if you think this is him, tell me, because those guns are gone today. And that is not what he's told.
You know, we've heard this time and again, even in the Crumbly case, the gun is a part of the lifestyle, and it's given as a way of creating or trying to create a bridge between parent and teen. And so it's difficult now to say that that was the cause of, or you should have known that that would be used in this type of crime. I struggle with that idea. All right, we'll take a break here. When we come back, we'll have more from the defense. Keep it here on Court TV.
This is the story of the Richins. Eric, a father of 3, met an untimely end, and Corey, his widow, wrote a children's book on grief.
She's also charged now with his murder.
He was faced with betrayal and terror.
I know her innocence.
Is their story a tragic romance?
Or a twisted tale of grief?
The truth will come out.
The Grief Author Murder Trial. Live coverage begins February 23rd on Court TV.
Let's head back to Georgia now, where the father of an accused school shooter is on trial this week on charges that he played a part in that shooting. Now, prosecutors say Colin Gray allowed his son Colt to possess an assault-style weapon that eventually was used to kill 2 teachers and 2 students in a shooting at Apalachee High School back in 2024. Well, now he's facing multiple charges, including second-degree murder. Let's head back into that courtroom now. We've been listening to the defense's opening statement.
It shows that Colin, had he known, would have removed those guns, but he didn't. Let's talk about what Colin actually did, because this case is being framed as if Colin Gray didn't do anything. The evidence will show the opposite. You will hear that when the family transitioned schools, it was Colin Gray who registered Colt. You will hear that Colin Gray worked full-time, was raising 3 kids on his own, due to his the kid's mother's addiction problems, due to DeFax saying that she was not allowed to have unsupervised contact with him, due to the courts in Barrow County saying she was not even allowed in the same county where these kids lived. Colin was doing everything. Colin is the one that filled out the counseling referral forms. Colin is the one that communicated with the school counselor. Colin's the one who discussed the evaluation. Colin was the one who was coordinating mental health services through the school. Colin is the one that filled out the paperwork to get the assessment done on September the 5th. You'll hear that the school had arranged, and it had already been taken care of, that Colin had completed everything he needed to for the assessment. You're going to hear from the grandmother who says that they wanted to take him to Advantage Behavioral in Athens, that it was urgent. This comes out after the shooting. The grandmother will also tell you she had absolutely no idea that Colt had any interest in Nicholas Cruz or school shootings in general until after the shooting happened and they were making the 4.5-hour trip from Fitzgerald, her and her daughter Marcy, at which point Marcy said, well, Colt does like this school shooter named Nicholas Cruz. That's the first time that you hear Debbie learns any of that. You're going to see text messages from Debbie in August and September of 2024 when she says that they were so strongly trying to get him into a facility. What you're not going to see in those text messages is any urgency on Debbie's part. You're not going to see anything from Debbie saying, get the guns out of the house. You're not going to say anything from Debbie saying, I'm worried about Colt. We need to get him there today. Nothing. They don't talk about it at all. Debbie doesn't mention it one bit. Now, she mentions it in hindsight after the fact, and Marcy does the same thing. Who's Colin Gray? He's a working father raising 3 kids by himself. He had responsibilities, he had a job, he had a family to keep afloat. He had 2 other kids besides Colt. He was involved. You'll see his text messages to his children. You'll see his text messages to Colt. This is not a parent who's turning his back on what's going on right in front of him. Let's talk about what you're not going to hear. Because sometimes what you don't hear in a case like this is just important as what you do. Sometimes the absence of evidence tells you more than the evidence itself. You will not hear a text message where Colt says to his dad, I'm going to shoot a school. I'm bringing a gun tomorrow. I have a plan. I'm going to hurt someone. You won't see a single message like that. You will not hear that Colt ever told his father about the notes on his iPhone. You will not hear that Colt ever showed his father a plan. You will not hear that Colt told his father he was accelerating the plan. You will not hear that anyone called Colin Gray and said, your son is about to commit a shooting. You will not hear that law enforcement told him, your son made a credible threat. You will not hear a school official warned him his mental health treatment is imminent. He needs to see someone today. You will not hear anyone from DeFax told him, we have serious concerns that he is violent, that he's going to hurt someone else. You will not hear anyone say that they contacted the police on September 3rd and said there's a school shooting about to happen. You will not hear that Colin Gray encouraged violence. You will not hear that he glorified violence. You will not hear that he dismissed a specific credible threat. In fact, you'll hear something entirely different. You'll hear that Colt suffered from anxiety. You'll hear that Colt suffered from depression. You'll hear about his panic attacks. You'll hear that he didn't like going to school. These are serious issues, but these are not the same as homicidal ideations. These are not the same as suicidal ideations. These are not the same thing as proof of a probable school shooting. The state will ask you to connect dots after the fact using hindsight, dots that became visible only after the shooting itself. But what you will not hear is evidence that at the time, Colin had sufficient warning that this outcome was probable, not imaginable, not possible, but probable. That Colin knew that his son would harm someone else. You'll hear testimony from Colt Gray's counselor. And that's important because it gives you a professional's perspective on what was going on with Colt in the weeks leading up to the shooting. You will hear that Colt presented as a student suffering from anxiety and emotional instability, panic symptoms, and inability to function in class. And you'll hear something very important. You will hear that even the school counselor, a professional trained, did not perceive Colt as a threat. She described him as nice, respectful. That matters, because if a trained counselor did not perceive the imminent violence, then it's unreasonable to claim that the father should have seen it himself. You'll also hear testimony from her about how the father did in fact take steps to get him mental health treatment. The father was in communication with the counselor. The father submitted the paperwork. The father completed the referral, and the father was pursuing intervention. You'll hear the therapist was essentially scheduled to meet with Colt the very next day. The father was not ignoring the problem. Colin Gray was acting. They want you to hold him responsible because they don't think he was acting fast enough. You'll hear from his daughter, Colt's sister, Jenny Gray. Her testimony will corroborate the concealment that Colt was perpetrating on his family, on his dad. She'll testify that Colt was secretive, that he was constantly deleting and opening new accounts on Discord to avoid detection.
All right, let me check back in with our guest, criminal defense attorney Josh Schiffer. And Josh, I think the defense is really, they're showing that they learned from the case of the Crumbleys. The big problem in the Crumbleys was, and I've thought this about that case, is how little the family seemed to care or do. They seemed to be apathetic about what was going on with their son. Here, defense really is focused in on the fact that the father was not apathetic. He was trying the best within his power to do something to help his son, and was not and could not have been aware of what was going on in his son's mind, partially because the son was being deceptive about those types of things and thoughts.
Yeah, and there's not a manual for raising teenagers. It's really hard. What worked for one doesn't necessarily work for another. And anybody that's been around teenagers, or maybe even been a teenager, knows that when teens are clamped down on, that's when they act out the most. So when you've got someone who's being deceptive, when you've got someone who you just don't have that trust with due to the development that every human being goes through and how that's managed, that really becomes hard when it comes to, hey, you didn't do this right, so you go to prison. Lots of teenagers have acted out and caused harm to people, maybe not this level of harm, but how have we as a community held parents responsible before? We get to the very standard, oh, kids are kids. You just got to deal with the fact that young people are violent, unregulated, emotional time bombs. I sure was. I was a disaster at times as a teenager. Good Lord. Thankfully, I wasn't allowed to have access to some of this stuff, but that's not in every family. Guns are a fundamental part of existence here in Georgia. They're in so many houses. You get into this very awkward position when you start prosecuting otherwise law-abiding people about how they do or do not control their firearms, and that's why this is so fascinating.
Yeah, and as I said earlier, I struggle with the idea that you have a culture that promotes gun ownership, a culture that promotes hunting and those types of things, and a father who, at least according to the defense, is sort of reaching out to his teen son with an activity that's as, normal as apple pie through this gun, saying, hey, we're gonna get out. We're gonna get you from behind the computer. We're gonna go hunting together. We're gonna bond over this. And then if it doesn't turn out that way and this kid turns out in a different way, they want to prosecute.
And we've talked about how polarizing the case is so important for defense lawyers and trying to break a jury. Remember, the defense doesn't want 12 people all sitting around saying kumbaya. This is about dividing it, turning guns into culture. That polarizes the jury.
All right, we got a lot more to talk about here, folks. Coming up, we're going to have more of the defense's opening in the Gave My Son a Murder trial. Keep it here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala, and we are in Georgia this afternoon for the Gave My Son a Gun murder trial. Defendant Colin Gray is accused of giving his son the gun used in the 2024 deadly school shooting at Apalachee High School that left 4 dead. Then, 14-year-old Colt Gray allegedly took a gun to school on the morning of September 4th, where he then fatally shot 2 students and 2 teachers and injured 9 others. Prosecutors say Colin Gray knew of his son's deteriorating health and alleged obsession with school shooters, but decided to give him a gun anyway. All right, I'll get you back to court now for more of the defense's opening statement.
He was using usernames that were combinations of alphanumeric combinations. You'll find that he would not discuss, based on the statement that Jenny gave on September 4th of 2024, that he would not discuss school shootings or school shooters in front of his father. You will hear in the morning of the shooting, Colin Gray had already left home. You will hear that Colt, when he did discuss school shooters with Jenny, made her promise not to tell his dad. You'll hear that morning on September the 4th, Colin Gray got up and took his youngest son, Coley Jr., to school, that he left before Jenny and Colt did to catch the bus. You will hear that Colt had to go and find the gun because it wasn't in his room, that he had to find the ammunition that wasn't in his room, and that he had to put them in his backpack, and that he had to conceal the rifle that stuck out of his backpack 18 to 24 inches with a poster board. Then he put a hat on top of it. It proves concealment, it proves independent action, and that matters because it's consistent with what Colt had done the whole time, which was conceal this plan from his father. Remember, the state says that he knew. They said that he knew this was going to happen. That he knew, not that it was possible, that he knew Colt was going to go and harm someone else. But you can't consciously disregard a risk that you're not aware of. And you can't say something is probable when it's being hidden from you. You're going to see text message. They've already discussed some of the messages. We're going to discuss some of the other ones. And we're going to talk about why they matter. There are hundreds of text messages between Colin Gray and his son. These texts matter because they show the reality in real time of what was happening and what Colin would have thought and what Colin would have known at that time. Not now, but at that time. They also show what Colt chose not to disclose. You'll see a father checking on his son on a daily basis, checking on school attendance. Did you make it to school? How's your day going? How was your day? What are you doing after class? You'll see encouragement. I'm proud of you. I love you. You're a good young man. This is not an absent father. This is not a father not paying attention to his child. You'll see daily involvement. You'll see a father trying to keep a teenager engaged and connected to school. You'll see a father trying to build the confidence and self-esteem of his son. You will see this all in the text messages. You'll see their discussions about mental health, about depression, which is not homicidal ideation, about anxiety, which is not homicidal ideation, about anxiety, panic attacks, which are not homicidal ideation. You'll see a father trying to stabilize a situation at home. You will not see threats to harm other folks. You will not see threats to harm other people. You will not see, I'm going to shoot up the school, I'm bringing a gun, I have a plan, I'm going to harm someone. There needs to be proof that Colin Gray knew what Colt was going to do and knew that Colt was going to harm someone. The text messages show something else as well. They show that Colt was capable of living a double life. He could text his father, love you, and have a good day, while simultaneously writing plans on his phone about shooting up the school. He could talk about liking school. School was good. The kids here are mature, referring to the Apalachee High School. They gave me a nickname. The teacher said I'm the tech guy. And you'll see Colin respond happily that his son seems to be finding his way for the first time in a while in school. He could talk, Colt, about school being good, about having a good day, and what they're going to have for dinner, while also planning on how to sneak a rifle into the school. That's not something a father can foresee. He asked about ammunition. You'll hear evidence that they went to the gun range. You'll hear evidence that he taught his son safety. You will not hear evidence that Colt requested ammunition because he was getting ready to do a school shooting. That conversation is not a threat. There's no mention of harming anyone else. There's no talk of a timeline. The state's going to ask you to interpret these ordinary messages with extraordinary hindsight. But the law does not allow hindsight convictions. You're tasked with determining what Colin Gray knew in the months leading up to the shooting. It requires proof of what he specifically knew at that time. You'll hear from the mother, Marcy Gray. She'll try to convince you that she warned everyone and no one listened. The evidence will show that she did not share the most important information she knew about Colt with Colin. You've already heard their relationship was not smooth. You heard that DeFax took the kids from her. You'll hear that they were separated. You'll hear that the kids had to come up here for the DeFax order. You'll hear that she drove up here after telling her mother she was going to murder Colin. Came up here, keyed his cars, got arrested, and then was told by the judge, you can't come back to Barrow County. You'll see evidence in text messages between Colt and his mom. You will see in these text messages Colt telling his mom prior to the shooting that he had created a securus online profile that he was using by making up a fake age to try and get in contact with Nicholas Cruz in prison down in Florida. He will text her that he had emailed Nicholas Cruz a couple times, and he'd even put money on his commissary. Marcy's response is to ask him where he got the money. And he tells Marcy in a text message, I told Dad it was to buy a video game on Steam. To which Marcy responds with a laughing out loud emoji. Marcy knew that he had this interest in Nicholas Cruz, but she did not share it with Colin. Immediately after this conversation, you will not see a text message from Marcy to Colin say, hey, did you know he's been emailing a mass murderer in Florida? Did you know that he put money on this mass murderer's commissary account that he told you was for a video game? She doesn't share any of that with Colin. She keeps that to herself. She does not reply immediately after to Colin or tell him, hey, this is what's going on. We got to get the guns out of the house now. No, she responds with a laughing out loud emoji. That's how serious she took it. She didn't think anything was going to happen. Remember, the evidence will show that even she, with the information that he did not have, did not believe there was an imminent threat and did not believe that Colt would harm anyone else. She didn't call law enforcement. She didn't seek an emergency mental health evaluation. And you'll hear evidence that after the shooting, her conduct is inconsistent with what she tells the police. You'll hear evidence that even after the fact, she's still trying to assist him in contacting school shooters and amplifying his profile across true crime community websites. And that matters because credibility matters and bias matters. You will see that the state is asking you to convict Colin largely based on a hindsight narrative provided by witnesses who are not credible, that did not recognize the warning signs in real time. You will hear from the victims in this case. Their testimony will be emotional. And it's important to understand what happened inside that school. But respectfully, their testimony will not establish what Colin Gray knew and didn't know. They can't tell you what was said in the home. They can't tell you what was concealed. They can't tell you what was sent in text messages. And they can't tell you what warnings were communicated to Colin Gray. We're not going to dispute the horror of what happened. We're not going to dispute that they were harmed, that they were physically harmed and mentally harmed. But that's not proof that he was negligent. That is not proof that he knew what was in Colt's heart, that he knew what Colt was planning, and that he knew that Colt was going to harm someone else. The law doesn't punish what is possible. The law does not punish what is conceivable. He is charged with knowing what would happen. He is charged with knowing his son would harm someone else. In life, almost anything is possible. It's possible that a teenager who's angry might get into a fight. It's possible that a teenager who's depressed might run away or make up excuses not to go to school.
All right, so you can see what the defense is doing there. He's telling this jury, you want someone to blame. Blame the mom. It seems like that's what he's saying. All right, we'll take a break. When we come back, we'll have the rest of the defense's opening statement. Also, we have an update for you. Interesting update in the Nancy Guthrie case. Keep it here on Court TV.
A deadly school shooting.
I just started hearing gunshots.
Now the father of the alleged shooter is on trial.
Mr. Gray knowingly allowing his son to possess a weapon.
The Gave My Son a Gun murder trial today on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
All right, folks, we have breaking news out of Arizona where TMZ is reporting that they've now received their 4th email demanding money for information on the Nancy Guthrie case. Now, that email with the same Bitcoin account as the other 3 notes says in part, I know what I saw 5 days ago south of the border and I was told to shut up, so I know who he is and that was definitely Nancy with them. This is the second reference to there being more than one person involved in the purported abduction of the 84-year-old mom of Today's Show host Savannah Guthrie. Although investigators have still not announced any suspects in the case, the search for Nancy Guthrie is now in week 3 as Savannah Guthrie continues to plead to the public over the weekend for any information at all on her mom's whereabouts.
I wanted to come on and it's been 2 weeks since our mom was taken, and I just wanted to come on and say that we still have hope and we still believe. And I wanted to say to whoever has her or knows where she is that it's never too late. And you're not lost or alone. And it is never too late to do the right thing. And we are here. We believe. And we believe in the essential goodness of every human being. And it's never too late.
All right, here's the latest developments in the case so far. The FBI said that DNA was recovered from the glove found near Guthrie's home. Now, the DNA is from an unknown male, and now the FBI is testing that DNA. The glove appears similar to those worn by the suspect seen on Guthrie's doorbell camera. You remember that video? Sheriff says that DNA was found at Guthrie's home that is not hers or those of her close contacts. Now, we knew that as well. Again, that continues to take just the weirdest turns. Let's bring quickly in our guest. Still with us, criminal defense attorney Josh Schiffer. Josh, these latest developments, and I've said throughout, this is the weirdest case I think I've ever seen in my career. I mean, it doesn't have the markings of a kidnapping for money. There's some speculation this weekend that this was a robbery or some kind of burglary gone wrong. But all these things that keep happening, they just seem to make no sense. I'd love to get your thoughts.
I'm in total agreement that this is one of the most odd factual evolutions of anything like this I've ever seen, because it started out in one perspective. Very quickly, other perspectives were raised that were very real. Was this a professional? Was this a burglary? Was this a crazy person? Was this a stalker? Was this a family member? And then you've seen, and I'm just going to rip the Band-Aid off, some really challenging responses from law enforcement that do not provide a lot of faith and security and integrity to what we're seeing. It's clear that the federal authorities and state authorities are having some conflicts. We're now seeing third parties that we don't even know if they're legitimate or not, communicating with the mass public through TMZ of all places. It just doesn't give me any faith that anyone's closer to finding Nancy Guthrie, and they keep chasing whatever leads are out there. It's a disaster, and I understand why Savannah Guthrie's family probably, in fact, we know, used their own personal third parties to assist in this investigation, because I don't think they have any faith in law enforcement and are getting very desperate.
Yeah, it seems like all parties there are at odds with each other on some level for sure. There seems to have been, I don't know, some missteps in this. Like you said, rip off the Band-Aid. That's just a nice way of putting it. And right now I understand there's over 18,000 tips that all the authorities are working with. So I'm not sure we're any closer at all to finding out what's going on here, all right? But certainly we keep that family in our hearts and prayers. All right, Josh, stand by. I want to take folks, back to Georgia, where a father is standing trial for his alleged role in a deadly school shooting allegedly committed by his son. The prosecutors say that Colin Gray gave his 14-year-old son an assault-style weapon, despite his obsession with school shooters, including a shrine in his bedroom to the gunman in the 2018 Parkland school shooting. Of course, the defense says dad had no idea about all that. It was actually mom who knew about it. Let's get you back into court now for the rest of the defense's opening statement.
It's possible that a teenager who's anxious might break something or act out. But this is not a case about whether something bad is possible. This is a case about whether or not Colin Gray knew Colt was going to take a gun to that school and harm other people. That matters, because if the standard becomes it could have happened, then the law becomes limitless. If the standard becomes you should have imagined the worst, then every parent becomes criminally liable for what a teenager might do. But that's not the standard. The standard is proof. Proof that Colin Gray knew, that he consciously disregarded, not a vague fear, not a general worry, but a risk that made this tragedy. That he knew Colt was going to go to that school. That he knew what the counselor didn't, what the DeFax professionals who had met with Colt didn't. The state will ask you to look at the outcome and then work backward to say because this happened, it must have been foreseeable. But the law doesn't allow hindsight to substitute for evidence. That's why you're going to hear about what was actually known at that time, and most importantly, what was actually hidden from Colin Gray at that time. Because when someone conceals a plan, deceives the people around them, acts independently, the law does not allow us to pretend that the people left behind should have seen through all of it. They're going to say that common sense means you should have seen this coming. And guns are serious, and this tragedy is serious. But the law is serious too. This case is not about whether or not firearms are dangerous in the abstract. It's about whether Colin Gray, based upon what he actually knew, failed to act because he knew that his son was going to go to that school and commit these acts. In a case like this, there's a natural human instinct. When something this awful happens, we want an explanation. We want someone to blame. We want a story that makes sense so that we can take steps to make sure something like this never happens again. It's very easy and it's very human to look at the end result and believe that someone, somewhere, must have known. But the evidence in this case is going to show something that's deeply uncomfortable. Sometimes the truth is that the person who committed the act was hiding it. Sometimes the truth is that a family can be struggling, a child can be spiraling, and people can try to get that child mental health help. And still, something unthinkable can happen. It's not satisfying and it doesn't give anyone peace. But the criminal courtroom is not here to provide a scapegoat. It's here to provide justice. Being a juror, providing justice, that requires discipline. It requires that we do not convict someone because we're horrified. It requires that we do not convict someone because we wish they would have seen it coming. It requires that we do not convict someone because we feel like there must be some accountability somewhere. The state has chosen to put the father on trial for what the son did. And at the end of this case, you'll be asked to decide whether the state has proven, beyond a reasonable doubt, that Colin Gray knew his son would go to that school and commit these violent acts. And at the end of this trial, you will find the state cannot prove that beyond a reasonable doubt. And we will ask you to return the only verdict that the evidence can support, which is not guilty on all counts for Colin Gray. Thank you.
All right, let's bring back in our guest, still with us, criminal defense attorney Josh Schiffer. And Josh, let's talk about some of the themes going on in that defense's opening statement. One of them, of course, is the idea that this crime was not committed by the father. This was committed by the son. So you got that. But I think one of the more important things that this defense is claiming and they need to do, and what they said they will do, is through these text messages and all the surrounding information, put this jury in the shoes of the father so they can understand what he knew so that they will know that he could not have known. It was not foreseeable from his perspective that his son could do this.
One of the most brilliant tools a defense lawyer and bluntly prosecutor, any other litigator can use is role reversal and changing that perspective, because we're actually not allowed explicitly to talk about role reversal and getting in that person's shoe, take a walk a mile in my client's shoe. We can't be explicit. That violates the golden rule, but you can dance all around it, and that's exactly what the defense is building a foundation of. I love the line at the end about putting a father on trial for what his son did. That really gets to the heart of the fundamental policy question that the defense wants this trial to focus on. The defense has terrible, traumatic, emotional facts. They can't get away from that. And the defense acknowledged and respected those facts. You didn't see a bunch of actions that would turn a jury's ears off. He kept them engaged by not excusing, but by more fully filling in what really happened. And I think the idea that a teenager hid their actions, their beliefs, their secrets from their parents, man, that's a story I can buy. I lied like a crazy kid when I was a teenager. Shoot, my parents, God rest them, they must have thought that I was a little bit more of an altar boy than I might have been. And I think juries can stand back and go, yeah, kids are good at hiding stuff from parents. How can you hold dad responsible if this was hidden from the dad? Yeah, so that's really the fundamental question. And man, there's good stuff brewing in this defense argument so far.
Yeah, I would have to agree. And like you said, we're all little angels, right? In the eyes of our parents. I mean, that's just fundamentally to being a parent, right? At the end of the day. And I can't imagine you being a nightmare on any level. So there's that. Quickly, I got about 30 seconds left here. The idea that it seemed to me that the defense was trying to demonize the mom, saying, hey, you really want to blame somebody here? Look at the mom, who knew much more than dad, and he had the kids, but she didn't tell him about it.
Yeah, just because you've got a silver bullet doesn't mean you stab him a little bit in the side as well, just to make sure. The defense wants to cover all of its bases, including, we talk all the time about that third chair, the empty chair defense of, hey, listen, we know this looks awful, but check out this person in the stool next to me. That's who you really need to be focused on, because it's not about telling the jury the state's wrong. In a case like this, you can agree with the state, but say it's not a crime. It's awful, but it's not a crime. What about these other people? That's how you win a jury with an ultra complex bit of litigation like we're going to be watching.